It's good to see you again.
Good to see you.
And I can tell you exactly. I was going through the jury, and I was like, I know exactly who's sleeping and when, because I was going through all of the testimony. I can tell you the only two they were awake for was the first witness, not just because it was the first day, but just because it was, the president of film production. There's about five guys that really, really like movies, and Joe can attest to it too. We were there yesterday. Juror 1, 2, 3, 7, and 9. Love movies, love Zendaya, love Aquaman, or at least Jason Momoa. And the other one I think they were awake for was Morgan Knight, Mr. Hicksville, and that was probably about it. The rest of it was kind of a meh. Knowing the jury and
And
studying them yesterday.
and then for the people who are watching, who are expecting that great testimony from the friend of Amber Heard's
Jennifer
sister,
Howell.
that never went anywhere.
That
Yeah,
was so disappointing. Utterly,
yeah,
utterly disappointing.
I'm trying to figure out where they plan on. I mean, so presumably, I was half spacing in and out of this thing by that time. But I can't. Did they actually get the letter in evidence? It kind of seems like they did, but it was never published.
I don't think
No.
so. I think it was referenced, but not an admitted exhibit, as far as I could tell. I mean, I do.
When you say letter, you mean the declaration? Is that what you're referring to?
Yeah.
No, her email.
Oh, but her declaration, I don't think got in either. I don't know what the hell happened. Why am I
So
hearing
it's
this
like-
echo now? I didn't do
It must have been excluded, or they chose not to. I can't believe they chose not to call it, not to introduce
Yeah.
it.
Now, arguably, I'm sorry. You go ahead, Nick. You want to talk, so.
Yeah.
Sure.
Check while I talk. Check the private chat.
Okay.
Real quick. I got a message for you in there. So. No,
that's what I said. That's what I said. The same thing.
It's just it's like you're calling her to rebut Whitney Heard's staircase story, and she doesn't end up doing anything. I mean, she testified that she was doing this because she saw someone she loved doing something so wrong. It's like, well, okay, well, let's get specific about what was wrong. She's lying. She's lying, and you know she's lying. You have a prior inconsistent statement. Where the hell is this? Where's the offer of this as evidence? Where's the testimony about it? And if this thing was excluded in limine, don't bother calling her, because it was just confusing as to why she's there.
Yes, that's what I think happened. I think they got brain locked, and this happens to attorneys sometimes, especially when you're this deep into a case. I think they were expecting that they were going to get her testimony in, which, in case you're unfamiliar with what the testimony we all are expecting from Jennifer Howell, it was that Whitney came running over there after the fight on the staircase between Amber and Johnny, and that Whitney told Jennifer Howell, her boss, when she moved into her place, that Amber tried to kill Johnny. Completely the opposite of the testimony that she provided when Whitney related the story from the stand, where Johnny's grabbing the back of Amber's head and punching her, one hand being in a cast, whatever. But whatever story she was telling, that it's completely different what she told a long time ago to Jennifer Howell compared to what she related on the stand. Now, as Nick pointed out, normally you would think this is hearsay. It sounds like classic hearsay. How can Jennifer Howell talk about a conversation she had with Whitney? It's not a statement from a party opponent. And the reason you would get it in is because there's an exception to hearsay for a prior inconsistent statement. For the purposes of impeaching testimony, you could say, well, this is what you told everyone on the stand, but this is not what you told people in the past. And you would think that would be a valid exception and that the court would allow it. It seems like this morning, when they had the pre-trial conferences between all the attorneys, that they probably brought this up, and the defense knew it was coming, and they said this is hearsay, and I'm sure this argument was made as to whether or not it should be allowed in as a prior inconsistent statement, and apparently the judge said, no, it is hearsay, I'm not going to allow it in. This is our speculation. We didn't hear it, but this is our speculation as to how the conversation must have gone. So they sliced that out. But when you slice that out, that's the whole meat of the freaking testimony.
It's the only reason to call her.
Yeah, it's the only reason to call her. So in your brain, you're like, oh, we're calling her. She's part of the thing. But you just carved out the entire entree, and you're left with like 2/3 of an overcooked appetizer. And it's the end of the day, and everyone's bored. And you're like, why are we watching this? And the jury's confused as to what they get out of it. They get nothing from it. and you just wasted time for nothing. And when you're the counsel, it's hard to realize what's happening when you carve out such a major chunk of the testimony sometimes. Maybe that's why I got stuck in there. That's what I think you're saying, and that was my takeaway. Exact same thing when I was watching the testimony.
Well, it's the only thing I can think of that makes sense is that it was excluded, and they then called her anyway. I guess maybe to cast some shade on her truthfulness character, so to speak, without a chance for her to rehabilitate it. But it was